25th. Can we have a motion to approve the agenda, please? Councillor Taylor, second by Councillor Sherwood. All in favor?
Yes.
Any disclosures of direct or indirect pecuniary interest? Seeing none, could we have a motion to move into close, please? Councillors Andrews and Post, all in favor?
And Mr. Mayor, if you can just, do you want me just to expand, because you maybe don't have it in front of you, just with respect to it's regarding the closed minutes for October 12th, October 15th,
Yes,
October 18th.
I've got it in front of me.
And yeah, the Orangeville Police Service arbitration litigation or potential litigation, including matters before administrative tribunals affecting the municipality or local board, and advice that is subject to solicitor-client privilege, including communications necessary for that purpose, labor relations, or employee negotiations.
Very good.
Thank you, sir. And now we'll pop into the meeting invite that I sent you, please, council. And that was carried, right? That was noted as carried, Mr. Mayor?
Yes.
Thank you.
Carried. All right. So we're leaving this meeting and popping into the other one. Thank you.
Mayor,
meeting. So,
okay,
Madam Clerk, we're still going to follow through with national anthem, land acknowledgement,
Yes.
those items.
Just
Okay.
give me 1 second here.
please.
Are you
Once,
there?
once
Good to go?
Dan lets you know that he's ready to go, Mr. Mayor.
Okay, so,
Yeah,
so
so I just need to
Mr.
check.
Harney, if you can bear with us for a few minutes here, we just have to knock off a couple of items here on the agenda. Dan, let me know when you're ready to go.
Sure, Mona, are you there?
Yes, I'm ready.
Okay, you're ready to go? Okay, so we're good to go anytime, Mr. Mayor.
Okay, so if Dan, if we could ask you for the singing of our national anthem, please.
O Canada, our home and native land, true patriot love in all of us command. With glowing hearts we see thee rise, the true north strong and free. From far and wide, O Canada, we stand on guard for thee. God keep our land glorious and free. O Canada, we stand on guard for thee. O Canada, we stand on guard for thee.
All right, thank you to David Nairn, the Artistic Director of Theatre Orangeville, for that rendition of our national anthem. I'd like to read our land acknowledgement statement. We would like to acknowledge the traditional territory of the Anishinaabe people, including the Ojibwe, Potawatomi, and Odawa of the Three Fires Confederacy. This meeting is being aired on public television and are streamed live and may be taped for later public broadcast or webcast. Your name is part of the public record and will be included in the minutes of this meeting. Earlier tonight, we had a closed session of council, and we are rising and reporting the contents of that meeting. There's a recommendation that the minutes of October 12th, 2021, October 15th, 2021, and October 18th, 2021 closed council minutes be approved, and that Orangeville Police Service arbitration regarding litigation or potential litigation, including matters before administrative tribunals affecting the municipality or local board, and advice that is subject to solicitor-client privilege, including communications necessary for that purpose, labor relations, or employee negotiations be received. Moving on to item 10, this is adoption of minutes of previous council meetings. So we have the, again, October 12th, 2021 special meeting minutes, October 15th special meeting minutes, and the October 18th council meeting. Could I have a motion to approve those minutes, please? Councillor Post, second by Councillor Andrews, all in favor? Thank you. Moving on to
Mr. Mayor, so if I may, that will also include the, we'll include the same mover and seconder for the Risen report.
very good. Yes, we can add that. Thank you. Thank you, Madam Clerk. All right, moving on to 11.1. Earlier today, Councillor Post and I unveiled the community art mosaic in the atrium at Town Hall. Between June 28th and July the 9th, 500 Orangeville residents of all ages demonstrated their artistic talents by hand painting 4-inch by 4-inch tiles. Each mini artwork, when combined together, created an 8-foot by 12-foot mural that represents the historic charm of Orangeville and celebrates the unity of our community. Launched as part of this year's Canada Day celebration, the Community Art Mosaic allowed Orangeville residents to connect safely during the COVID-19 pandemic. On behalf of Town Council, I want to thank all of the artists who participated in this creative venture. I would also like to thank the Community Services Department for leading this project and Canada Heritage for their grant of $11,200 to complete the project through the Celebrate Canada grant. Residents are encouraged to visit Town Hall to view the mosaic during regular business hours and can watch the video now up on the town's Facebook page at Orangeville, Ontario Municipal Government. All right, moving on to 11.2. We're welcoming tonight our new Integrity Commissioner, Mr. Charles Harnick. Mr. Harnick, welcome, and we're looking forward to the education you're going to impart on us tonight. Thank you, sir. All the best.
Thank you, Mayor, and thank you, members of council. I've extensively reviewed your code of conduct and procedural documents, and I must say I have done this work for a significant period of time, seen lots of these codes of conduct, and have not seen one as comprehensive and well put together as the documents for Orangeville. So it leads me to believe that there's probably not a lot that I'm going to tell you that's really new, and I think that you've really sort of taken this to a pretty high level. And I know that your former integrity commissioner I know well, and I am certain that he would have had educational opportunities with council. And I can assure you, if that's the case, I really don't think I'm going to tell you anything that you haven't heard before. So I say that with the greatest respect for your former integrity commissioner, who is an old friend. But I do think it's worth periodically taking a look at things that you may over time take a little bit for granted or not consider and refresh. And I think that is really more of what this session is about than teaching you folks anything that you haven't probably already heard before. So I by way of introduction, I am a mediator, arbitrator, investigator. I've practiced law for many years. I've spent some time in the world of elected politics, so I have a bit of a feel for life as an elected member. I'm currently, in addition to the work that I do, I'm chair of Legal Aid Ontario, and I am still associated with a company by the name of Council Public Affairs that I founded many years ago with partners, and I still play a small role there. And as you see, I'm also the integrity commissioner for a number of municipalities. I do my work with ADR Chambers, who have provided dispute resolution services throughout Canada and internationally. We've been operating in the world of integrity commissioner world since 2011, and the most important aspect of ADR Chambers is that we are available, virtually 24/7. If I'm not available, somebody on our team is available that I can delegate to, and that can provide you the information you need when you need it. The Integrity Commissioner has two primary functions, and that is to review and report on complaints or requests for an inquiry, and even more important than that, it's to provide advice to council and council members so that you avoid issues around the code of conduct and around the Municipal Conflict of Interest Act. The role of the Integrity Commissioner has expanded significantly on March 1st, 2019. And at that time, integrity commissioners were given jurisdiction to investigate contraventions of the code of conduct. Up until then, it was not mandatory, and jurisdiction to investigate alleged breaches of sections 5, 5.1, and 5.2 of the Municipal Conflict of Interest Act. The standards of conduct for council members are set out in the Orangeville Code of Conduct, and that is for council members and members of committees. And the procedures are set out in a separate document or bylaw. And as I said earlier, your code and your procedures are probably as comprehensive as any that I've seen. And I will provide very little by way of advice to you to update or make changes in your code. The purpose of the Code of Conduct is to ensure that members share a common basis for accepted conduct. It's to provide a reference point and a supplement to legislative parameters within which members must operate. It's to enhance public confidence that members operate with integrity, justice, and courtesy, and it applies to every member of council, including the mayor. Members shall serve and be seen to serve their constituents in a conscientious and diligent manner, avoiding the improper use of the influence of their office and conflicts of interest, both real and apparent. Members are to perform their duties in a manner that promotes public confidence and bears close public scrutiny. And the overriding objective is to enhance public confidence in government and the political process. I note in your Code of Conduct, section 13.5, and I was really quite pleased to see this. And when you talk about public confidence, promoting public confidence, making sure that the use of your office is done properly. But I think it's the only code where I've seen where it refers to the administration of justice. And certain employees are employed within the administration of justice. Members shall refrain from making requests or statements or taking actions which may be construed as an attempt to influence the independent administration of justice. And I think that, when you talk about avoiding the improper use of influence of your office, that is so important. And the interactions that you have with bylaw enforcement officers, in a policy sense, direct them. But in terms of their day-to-day operations, that is something that elected people have to stay very far from. And you've acknowledged that in your code, and it's an example of what I referred to earlier as how sophisticated your code is. Members are responsible for making honest statements. No member shall make a statement when they know that the statement is false. No member shall make a statement with intent to mislead council or members of the public. Members will conduct their dealings with each other in ways that maintain public confidence in the office to which they've been elected or appointed, are open and honest, focused on issues rather than personalities, and avoid aggressive, offensive, or abusive conduct. And again, I think when I first read through your materials, they didn't refer to social media in any way. And I was somewhat surprised about that. And then I read the cases that Integrity Commissioner Giorno adjudicated, and one of them had extensive use of social media, and I was it showed me that the form of your current code is sufficient to deal with it, even though it is not specifically referenced. You may want to have include a definition of social media. You may want to make mention of social media in terms of honest statements. Again, I don't think you have to. Integrity Commissioner Journo's decision indicated that to me, but it's something you might want to think about. I don't think it's urgent. I don't think, I think you've managed quite well without it. But if you're concerned about dotting I's and crossing T's, it's something you might consider. And again, it all feeds into the role that an integrity commissioner has in determining what is political debate and what are policy statements, internal, government lawmaking apparatus, and the balancing of making sure we have unrestrained political discussion as opposed to dealing with restraints around that. So an important aspect of everything that we do. Only council as a whole has the authority to direct staff, approve budget policy or processes, including the structures and procedures for committees and other such matters. I see in your material that was sent to me dealing with staff relations, again, you have dotted all the I's and crossed all the T's and cross-referenced this with your code of conduct. So I think that you are very much up to date in terms of looking at responsibilities of council and staff. Council is responsible for and dedicated to providing good and effective government for the public in an open, accountable, and transparent manner. Members of council, when appointed to local governments, committees, or other bodies as part of their duties, shall make every effort to participate diligently in the activities of these bodies with good faith and care. Members shall accurately and adequately communicate the decisions of council and local boards so that respect for the decision and decision-making process is fostered. Members shall not attempt directly or indirectly to influence the decision-making process as it relates to the award of contracts or settlement of claims. And I just want to comment on the issue of accurately and adequately communicating decisions. I think that that is an imperative. And I think that once a decision is made by council, it's imperative that it accurately be communicated, even if you've voted against what council has passed. And I think you've got to be, you've got to take a very objective approach when you're reporting those decisions, as opposed to a subjective approach. Even and that's in spite of whether you agree or not. So just something to think about. The code of conduct at council meetings. During meetings, members shall conduct themselves with decorum. Respect for delegations and fellow members and staff requires members show courtesy, and you've got to deal with issues like handheld electronic devices, which you've done, and distractions and not engaging in private conversation. And again, I think it's all around respecting, creating the right conditions for healthy vigor and vigorous debate. I think, certainly the code of conduct certainly points at this. Members shall be respectful of the fact that staff work for the town as a body corporate and are charged with making impartial recommendations that reflect their professional expertise and corporate perspective. Any individual member or faction of council shall refrain from any conduct which may deter, interfere, or unduly influence staff in the performance of such obligations and duties. And no member shall maliciously or falsely injure the professional or ethical reputation or the prospects of or practice of staff, and all members shall show respect for the professional capacities of staff for the town. All members have a duty to treat members of the public, one another, and staff appropriately and without abuse, bullying, or intimidation. All of these things well covered. One of the important aspects of the Code of Conduct is the preservation of confidentiality. And all information, documents, and deliberations received, reviewed, or taken in closed session of council and its committees are confidential, except as otherwise directed by council. Members shall not disclose or release verbally, in writing, or by any other means any confidential information acquired by virtue of their office, except when required by law to do so. Members shall not permit any persons other than those who are entitled thereto to have access to information that's confidential. And personal information under the Municipal Freedom of Information and Protection of Privacy Act is confidential. A matter that's been debated or discussed at a meeting of closed council, unless the matter is subsequently discussed in open council or is authorized to be released by council, remains confidential. Reports of consultants, draft documents, and internal communications, which, if disclosed, may prejudice the reputation of the city, its officers or its employees, or its effective operation, those documents are confidential. Also confidential is information concerning litigation, negotiation of or personnel matters, procurement issues, etc. And again, those are all well set out in the Code of Conduct. Members shall not accept fees, gifts, hospitality, or personal benefits that are connected directly or indirectly with the performance of their duties, except compensation authorized by law. You do provide an exception if the value is $100 or less and received as an incident of protocol or social obligation that normally accompanies the responsibilities of office. No member shall seek to obtain or obtain by reason of their office any personal privilege or advantage with respect to town services not otherwise available to the general public and not consequent to their official duties. I really like the simplicity of your gifts and your gift sections, and I think they're straightforward, very understandable, and I think have probably not been an issue for council. The Code of Conduct deals quite extensively with reprisals and obstruction. Any reprisal or threat of reprisal against a complaint or for anyone or anyone for providing relevant information to the Integrity Commissioner is prohibited. It's a violation of the code to obstruct the Integrity Commissioner in carrying out his or her responsibilities. And again, I think that is well covered in the code. Members shall avoid conflict of interest or unethical behavior members shall comply with the Municipal Conflict of Interest Act. And I note that the Code of Conduct specifically deals with personal interest as opposed to financial or pecuniary interest. And I think Integrity Commissioner Journo has dealt with that in a report to Council. And I think that's a very important distinction. And I believe that your code deals with that.
Mr. Harnick, we have a councillor asking a question here.
Sure.
Would you mind? Councillor Sherwood.
Yes, Your Worship, through you. Can you explain to me when you have recommend that the Code of Conduct be updated to include provisions with respect to the use of social media and a limitation period? What is a limitation period, please?
Okay. I was just coming to that.
Oh, I'm sorry. I've jumped ahead.
Okay.
I'm
That's
sorry.
Okay. It means you're reading faster than me.
Oh, I thought. Sorry.
No, I want to talk about, social media. I think I covered earlier, and I don't really think you have to do anything dealing with social media. I think it's covered. As I say, if you want to dot the I's and cross the T's, you might want to apply or include a definition of social media and make mention of social media in the appropriate section where it could be added. I don't think it's 100% necessary. You've managed really well without it. Why muddy the waters or make things even more complicated than they are? So those are really my comments about social media. In terms of limitation periods, one thing that I have found is periodically claims pop up, and they show up a long time after the alleged infraction. And one of the things that I've seen and recommended in codes of conduct is something similar to what they have in the Municipal Conflict of Interest Act. And that is in the Municipal Conflict of Interest Act, I believe it's a 6-month limitation period. But for the purpose of code of conduct, it seems, realistic to maybe consider including a limitation period, meaning that would work something like this. You have 6 weeks from the time that you knew or ought to have known that an infraction may have occurred. You've got 6 weeks to bring the complaint against the member. And you have an ultimate limitation period of 6 months. So in other words, if you find out, 4 months after the infraction that an infraction might have occurred, and you've got basically 6 weeks from the time that you learned that the infraction occurred, which you'll usually learn about immediately. But you've got 6 weeks from when you learned about it. But if 6 months has gone by, you've lost your right to claim, to complain. But usually what happens is complaints are complainants know about the complaint at the time that the alleged infraction occurs. And it might be something to consider having a limitation period of six weeks from the time that the infraction occurred and no later than 6 months. And that way these things aren't hanging out there. There's less chance they can be used as a bit of a political sword. If you've got if an infraction has occurred, you've got 6 weeks from the time you knew or ought to have known about it. Usually that's at the moment that the alleged infraction happened. So I think, I think it's something you may want to consider. You've been fine without it, but I think it's a very good idea, simply because It doesn't allow for these things to hang out there for a long period of time. It doesn't allow people with a political purpose to play the game of gotcha. I think it puts an onus on somebody complaining to make their complaint in a timely way.
Councillor Sherwood has her hand up again, Mr. Harnick.
Just a follow up. So you're suggesting that with regard to social media, but is there a limitation period on other areas? Is there a limit? Are you going to be getting to that too?
Oh no, I'm suggesting that set social media aside.
Yes.
I'm suggesting a limitation period for everything.
For everything, whether it's something happened in the council chambers, out in the street, anything.
Right.
So our current code of conduct does not address limitation periods for anything right at this point.
As far as I could see, it doesn't.
Thank you for that.
So you may wish to consider that, and only because it forces a complainant to come forward early in the process. I've had situations where people have come along 2-3 months later. They knew about it at the time that it happened, but the politics of the day 3 months later said, "Boy, I don't like what this councillor's been doing. I'm going to bring that complaint now." And if you had a limitation period, it would have been long at a time. I've seen this in where there's been kind of a bit of a political vendetta going back and forth in particular councils, and a community member who sides with one side uses that as a bit of a political sword when the time is right, and this doesn't allow that to happen.
Thank you for that.
Okay. Just want to chat for a moment about requests for advice from the Integrity Commissioner. Members or council as a whole may contact the Integrity Commissioner in writing to ask questions and obtain advice. The Integrity Commissioner will endeavor to respond in writing to such requests within 5 business days or less in urgent cases of receipt. And that's something we endeavor to do quickly. I've come to the conclusion that it's pretty hard to imagine, somebody thinks of a request for advice because something is coming up, and that's when they turn their mind to it. Usually it's a request that is somewhat urgent. ADR chambers will often, if the Integrity Commissioner is not available, will get somebody else who is an Integrity Commissioner within ADR chambers, so we can respond to these things quickly. They tend to be generic in terms of codes being very similar, but it is something that we endeavor to do and turn around quickly because it's very important to members, and I think it just saves people a whole lot of aggravation. Surely, if somebody has a problem and they've gone out and they've requested advice and for the most part followed that advice, it's pretty hard to challenge them when they've been guided and followed the guidance. I think sometimes people, they think these problems won't arise, and they're reticent to come forward and ask for some help. And I hope folks will feel quite free to contact me, and usually my style of doing these things is I get a request in writing, I'm never sure based on the written request, 100% of what really the facts are. I endeavor to contact the person and arrange a phone conversation to clarify the facts for me, so I'm 100% sure that I understand the situation, and I then respond with advice. And so I hope people will feel free to contact me, but it's just a way of avoiding problems down the road. And that also goes for the Municipal Conflict of Interest Act. And it's just an opportunity to avoid an issue for yourselves, and that's one of the reasons the Integrity Commissioner is there. And I think it's no one should feel reticent to ask for advice, and no one should feel that there are any silly or stupid questions, because there aren't. If there's something you don't understand, that's what we're there for. So those are my comments on that. Just a few comments on the Municipal Conflict of Interest Act.
Mr. Harnick, before you move on, if
Sure.
Councillor Taylor wants to ask a question.
Oh, sure.
All right, I was on mute. Thank you very much, through your worship, to Mr. Harnick. First of all, Mr. Harnick, very nice to meet you tonight. Appreciate someone of your caliber being involved in our council meeting and serving us in this way. The whole piece about the Integrity Commissioner, it has a connotation to it. And even to get advice from the Integrity Commissioner sometimes has a connotation to it. And that is, it's a waste of money to contact the Integrity Commissioner. There's a cost to the taxpayer to be able to do that. So I think if anyone was to do it, you'd hope it was a very serious issue, and to your point, not politically motivated, and you were trying to get to the root cause of an issue. So I guess my question is, it seems like each offense in my mind is $4,000 to $5,000 to review, if it was something reasonable, to just simply get advice from the Integrity Commissioner. Is there how would you go about understanding what the cost to the taxpayers would be just to get advice?
I would say you can get involved in a conflict of interest issue, or a breach of a code of conduct issue that can cost thousands of dollars in terms of investigations and the extent that some of these things can go to. And if you can head that off by dropping an email to the Integrity Commissioner, having a phone conference with the Integrity Commissioner for half an hour, and having the Integrity Commissioner do some work on it. And usually you can do these things in a few hours. You're talking 4, 5, 6 hours a time versus 50, 60, 70, 80 hours a time. It's not unusual if one of these is a very significant issue that could have been headed off, that you're saving thousands of dollars for taxpayers. And I think it's not hard to make an argument to taxpayers to say, we have an Integrity Commissioner. I wanted to make sure I wasn't offside the rules. And in order to ensure that I wasn't, I contacted the Integrity Commissioner for advice, and I got advice. And the whole purpose of this is to transparently have a government that is adhering to all of the rules. And I think that that's something taxpayers really, they want to see that their government's working. And this is one of the ways you can demonstrate that it is. So I hope that answers your question.
I think so, sir. I guess the piece would be is it makes me personally angry when I see something go to the integrity commissioner and it's lost and it feels frivolous and then that money is spent, right? So you just, for me, I'm always trying to think about, is that a reasonable thing to ask? And I don't know, I think you answered the question. It's just, I wanted to share that there's this reluctance sometimes to employ an integrity commissioner.
Yeah, I'm going to get involved in a second in talking about the Municipal Conflict of Interest Act, which is very complicated. It's short, it's simple to read, but you get involved in issues of pecuniary interest and related pecuniary interest, and that can become very, very complicated. And if a call to a note to the integrity commissioner can head off, a very significant process that can wind up in court before a judge, and you can avoid that by seeking some advice. I think that the seeking advice is a small investment to save a whole whack of dough down the road. And I just think that that would resonate with taxpayers. And I think any member who goes out of their way as they would to seek advice really complies with the aspects of the or complies with really the purpose of the code of conduct, which is to establish general standards of conduct, and to operate from a base of integrity, justice, and courtesy. And it just seems to me that you're complying with the very essence of what the purpose of the code is all about. And I think that's an argument that taxpayers would readily accept. So I don't think anybody who needs advice should avoid getting it because they might be criticized because there's a small cost involved. Because if you don't seek that advice, you may be looking at a much bigger cost. And I guess I'm putting my political hat on, but that there's people out there who have different political ideas and support different people, and a lot of times, they're just looking for an opportunity. They're just waiting for a chance, and I think that as elected members, you've got to be really cognizant of that. And for me, one of the things that I, for right or for wrong, I think part of the role of the integrity commissioner is to understand what's politics and what isn't. And I think that's the world you live in, and you folks know it much better than I do.
Understood. Thank you, sir.
All right. Thanks.
If I may, I also find your trees in the background very distracting. Wherever you are, it looks like a beautiful spot.
Oh, it's a pouring rain day. I can't even see them now. It's dark. But I'm up in a little place called Clarksburg, Ontario.
Oh, very nice.
Up near, just not far north of you.
Thornbury.
Exactly the spot. So, and it's been a cold, rainy, miserable day for sure. Anyhow, I just want to say a little bit about the Municipal Conflict of Interest Act. Any elector or person demonstrably acting in the public interest may apply in writing to the Integrity Commissioner for an inquiry into an alleged contravention of Sections 5, 5.1, or 5.2 of the Municipal Conflict of Interest Act by a member of council or a member of a local board. A member has an indirect pecuniary interest in any matter in which the council or local board is concerned, if the member or his or her nominee is a shareholder, has a controlling interest in, or is a member of a body that has a pecuniary interest in a matter, or the member is a partner of a person or is in the employment of a person that has a pecuniary interest in a matter. You know, funny examples that come along, but you know, the situation of you know, somebody has a mortgage on a property, or somebody is a tenant of a property, and the property is about to is about to be redeveloped, and you know, does the member have a pecuniary interest? I mean, it doesn't really say that directly, but if somebody asked me what I thought, I sure would think that's getting a little close to home. You know, you'd be on pretty thin ice not declaring a pecuniary interest, but it's never black and white. It's always gray when you get into these things, and again, it's why you may want to seek advice, because it's a pretty tough decision to make, and you want to make sure you're doing it in a thoughtful way. For the purposes of the Municipal Conflict of Interest Act, the pecuniary interest, direct or indirect, of a parent or the spouse or any child of the member shall, if known to the member, be deemed to be also the pecuniary interest of the member. What happens, you know, that I mean, it's pretty clear, but what happens if the child is married to someone who works in an industry, and council's about to make a decision that could be pretty restrictive on that industry? That person isn't really a child, but you know, how broadly do you define these things? And again, I'd say everything in this area is gray, and you just have to be really alive to these issues. And there is significant jurisprudence on this, so it's a very, very difficult area. Where a member has any pecuniary interest, direct or indirect, in any matter, and is present at a meeting of a council or a local board at which the matter is the subject of consideration, the member shall, prior to any consideration of the matter at the meeting, disclose the interest and the general nature thereof, and shall not take part in any further discussions. And you know, I think it's important to understand that if you have a pecuniary interest, you can't do anything while the matter is pending, and it could be months and months until it finally gets resolved. But you can't do anything to try and affect the result or influence anybody on the other of your colleagues on the council. So you got to be very, very careful about that. And again, it's not just at the meeting itself that you can't take part. You can't have an influence while that matter is pending before council, and as you know, this can be many months until some matters are resolved by council. Where the interest of a member has not been disclosed as required by reason of the member being absent at the meeting when it first came up, the member shall disclose the interest and otherwise comply with the disclosure requirements at the first meeting of council or local board attended by the members after the meeting. So again, if you're not there and the matter did come up at the previous meeting, get up, disclose the interest, and make sure that you've filed your statement with the clerk. And at a meeting at which a member discloses an interest under Section 5 of the Municipal Conflict of Interest Act, or as soon as possible afterwards, the member shall file a written statement of the interest and its general nature with the clerk or the secretary of the committee or local board, as the case may be. So that's basically an overview of the Municipal Conflict of Interest Act. Just touching on a couple of the high points, I'd urge everybody. It's a very short act. I think it's got 12 sections to it, 12 or 13 sections, 15 sections. I'm sorry. It's very short. It seems very straightforward. I urge everybody to take a look at the Municipal Conflict of Interest Act, read through it periodically, keep it on your desk beside you. It's a very important piece of legislation. In terms of complaints, just to talk a little bit about process and procedure. A written request or a complaint requires a written request by an identifiable individual. They can't be anonymous in respect of a possible code complaint or a Municipal Conflict of Interest Act contravention. The complaint must set out the grounds for the allegation that the members breached the code or the Municipal Conflict of Interest Act with specificity. Some municipalities set time limits for submission of a code complaint. We've talked about that a few minutes ago. Some municipalities do that. A Municipal Conflict of Interest Act complaint must be brought within 6 weeks of the complainant becoming aware of the alleged contravention. And the complaint is filed directly with the Office of the Integrity Commissioner. And I note that you have an informal procedure, and the informal procedure does not prohibit, or it's not a prerequisite to filing a formal complaint. But I really think it's an important procedural opportunity, and that is, sometimes, somebody's intent on advancing a complaint. Sometimes there are continuing relationships that will exist after the complaint is resolved, and sometimes pursuing a complaint to a decision is not a best way to promote that ongoing association that you're going to have with that individual. So the opportunity to use the informal procedure and perhaps have a mediated resolution of the complaint is a much better way to maintain a relationship than the formal procedure that leads to a decision. So I just urge folks to think about that, and sometimes it promotes a much better decision than the narrow decisions that an integrity commissioner can provide, and it promotes a better continuing relationship between the complainant and the respondent. So something to think about. And I know that you're familiar with the fact that we take a look as integrity commissioners as to whether we have jurisdiction or whether there is another outlet that would be more appropriate for the advancement of the complaint. And I also note that you have left it to the discretion of the Integrity Commissioner to decline frivolous, vexatious, and bad faith complaints. I also like the fact that if a member makes such a complaint, then the Integrity Commissioner may identify the member to council. So I think that's a very healthy approach, and it doesn't exist in many communities. I think having it is a very important and good part of the process that you've created. I've set out the code investigation protocol, which I'm sure you're all familiar with. My only comment about the code investigation protocol is that you have challenging time limits that are part of that. I will only say that you've given a little leeway. I will do my best if indeed there is a complaint to comply with those very challenging time limits. But I see the benefit of it, which is that it gets it through the process without lingering, and there's always benefit to that. And you understand, know well that once there has been a contravention, the Integrity Commissioner can recommend a reprimand or a suspension of the remuneration paid to the member for a period of up to 90 days. And I think, the other thing that we do is we often will make a recommendation to council that maybe something should be, maybe there should be an amendment to the code, or maybe there should be, some changes to a policy in order to make the system work better. And again, it's all fact dependent on in any given case, but that is something that we will do. The Integrity Commissioner shall preserve secrecy with respect to all matters that come before the Integrity Commissioner. In a report on whether a member has contravened the code, the Integrity Commissioner may disclose such matters as in the Integrity Commissioner's opinion are necessary for the purposes of the report, and parties shall maintain confidentiality until the final report is delivered to council. One thing we have done at ADR Chambers is we provide an affidavit for the complainant to sign, acknowledging that that there is a duty to maintain confidentiality through the process. That is particularly important when the complainant is not a member. Members know that is something that has to be adhered to. Oftentimes, a citizen will not know that, and it's the opportunity for us to get that affidavit signed that reinforces in that person the need to maintain confidentiality. So we do that as an additional item to what your procedural document provides, and it just gives us and certainly the respondent to the complaint some comfort that the complainant is aware of their obligation to maintain confidentiality. If the Integrity Commissioner has reasonable grounds to believe there was a contravention of the criminal code or any other act, the Integrity Commissioner will suspend the investigation, report to the appropriate authorities, and report to council. The investigation would then remain suspended until the police investigation or the other investigation is finally disposed of. Oftentimes that resolves the problem anyway. There are similar investigation protocols for the alleged Municipal Conflict of Interest Act contraventions. The difference there is that there's 180 days to complete that investigation. and on completion of municipal conflict of interest investigation, the Integrity Commissioner decides whether or not to apply to a judge under Section 8 of the Municipal Conflict of Interest Act for a determination as to whether the member has contravened Sections 5, 5.1, or 5.2 of the Municipal Conflict of Interest Act. The Integrity Commissioner provides the municipality's clerk, the complainant, and the member with written reasons for the decision about whether or not to apply to a judge. And that's really related to the fact that a judge can declare a breach and then have a much wider latitude in terms of penalties. So and it enhances the gravity of the offense. So those are really the highlight areas that I wanted to cover today. And any questions I'd be happy to answer, with the caveat that it's hard for me to deal with hypothetical fact situations. So I try and avoid that to the degree possible.
Thank you, Mr. Harnick. Very informative, and thank you for your thoughts and advice to us. I'm sure council will reach out to you at the appropriate time if necessary. Thank you for that invitation, that wide invitation made. Councillors, any further questions of Mr. Harnick before we let him go? Seeing none. All right, Mr. Harnick, appreciate your time tonight, and thank you very much for taking on this task for us. And let's hope we don't have too many interactions with you, but we know that they'll be handled in an expert way if they do come before you. So thank you, sir.
Thank you, and thank you to members of council.
All the best.
Thank you to you as well.
Thank you.
Bye now.
All right, bye-bye now. All right, councillors and staff, we're moving on. Item 12, there are no staff reports for tonight. We have one item of correspondence. Council, if we could have a motion to receive item 13.1, please. Councillor Andrews, second by Councillor Taylor. All in favor? Any comments on that particular item? No. All right. I did that a little backwards there. Sorry. We should have asked for a commentary before we voted. Moving on, we have no committee board minutes. We have no notices prior to meeting. Any notices of motion at the meeting? Seeing none. Any new business, councillors? Seeing none. Madam Clerk, do we have any questions from the audience or the residents of Orangeville?
Mr. Mayor, I don't believe so, but Dan can confirm that. We actually did anticipate that the training session was going to take a little longer than it did. So public question period was advertised for 8. So I would just suggest just asking again if there's anyone on the line, and if there isn't, if Dan and Mona confirm that there isn't, perhaps we can just indicate if there are follow-up questions after someone has viewed this, they can certainly follow up at the next council meeting.
All right. If there's anybody on the line,
and just through you, your worship, there is currently nobody on the line. The YouTube feed is roughly 1 to 2 minutes behind, so we may just be catching up now if anybody did want to call in, but currently there is nobody on the line.
Okay. I'm sure they can reach out to the clerk, or again, as Madam Clerk has suggested, offer their questions at our next meeting. Councillor Taylor, you had your hand up?
Yes, your worship, if I may. It does sound like we're a bit awkward with the question period timeline, and if it would be all right, I did encourage a resident to phone tonight, and maybe I could do a little bit of a job on the question or comment that they had. And at the very least, if we don't get to it tonight, you know, the question is out there, and perhaps we can discuss it in the next meeting if that person is going to miss it. But there's a lot of concern about parking. You know, the thought process is the parking on one side of the street, there's wondering when that's going to come to council, and that will solve part of the parking. But the feedback that was given was, would council essentially consider parking for periods of time? So essentially 2 or 3 hours at a time. The feedback given is this individual was very frustrated that cars could park in front of his house for days and weeks at a time outside of the winter parking period. And, it was upsetting to those folks. And if you do get to hear this later on, and that's your question, citizen, I apologize, I'm not doing maybe the right job on it, but I have heard this from more than one member of the public, that we allow cars to stay fixed in spot for weeks at a time, and it doesn't move. And, would council consider something like this later on? I don't have a notice of motion. I haven't circulated this amongst my peers, being fellow councillors, but I did encourage the resident to call in and discuss, and maybe they've just missed it tonight, but I think that's the gist of it.
Okay. Madam Clerk, could you comment on that? Is there any bylaw in place that can be affected or enacted?
Well, I certainly the traffic bylaw, the traffic and parking bylaw can limit the length of time that you permit parking on any town road. As Councillor Taylor has indicated, right now there isn't a restriction in that regard other than your 2-hour parking limit. So I believe that Infrastructure Services is currently considering whether they're going to recommend or not recommend, I guess, no parking on one side of the street. And I don't know if that's part of the issue as well. But certainly there are different ways to address it, whether you do it that it's a complete parking prohibition or whether you limit the amount of time that you can park, are certainly options available to council. And I would suggest that those are things that you probably would consider as part of the report that comes back from Infrastructure Services.
Yeah. Yeah, parking's a very complex problem. The fact that the Planning Act allows lots to be so close together. Some of our newer subdivisions, there are effectively no parking spots available on some sides of the street because the driveways and the front lawns don't accommodate cars. It's so, maybe going forward, the town has to look at other public parking spaces, places to populate throughout town and maybe relieve some of this issue. But, and also as we're looking at further intensification, we're looking at basement apartments as being a way to solve some of the housing crisis. It just exacerbates the parking problem. So I think it's a big picture item that we've got to look at, but I think we need to look at additional parking lots beyond just Fendley Park and Rotary as relief parking. And I hope council can consider that sometime in the not too distant future. Any other comments, councillors, before we move on? No? Okay. So again, apologies if anybody is calling in on question period and sees our meeting is over. We'll certainly accommodate you at our next council meeting, and you can send your questions in by email or call the clerk's office to start that process. We're moving on to 19 now. This is the confirmatory bylaw for tonight's meeting. This is a bylaw to confirm the proceedings. I'm sorry, Councillor Peters, you have your hand up, or you're just, oh, all right. So let's have a motion on 19.1. Councillor Peters, seconded by anybody? Councillor Sherwood, thank you. All in favor? Thank you. And a motion to adjourn, please. Councillor Taylor, seconded by Councillor Post. All in favor? Thank you, everyone. Have a nice evening.
Good night.
Good night.
Good night, everyone.
Good night, everyone.
Bye. Bye.